My name is Elisa Arcioni. I'm an Associate Professor of Constitutional Law at the University of Sydney Law School. I am not Indigenous. I'm like half of the Australian population, either born overseas or with at least one foreign-born parent. Today I'm speaking on Gadigal land, Ninari Nalawangan Maribajari Gadinurada, which in the language of the Gadigal here in the Sydney Basin means, we meet to talk together on the beautiful country of the Gadi. My aim in this presentation is to explain some of the background of the Voice proposal that is the focus of the referendum at the end of this year, and to place it in the context of Australia's legal history and constitutional structures. I hope to provide you with some background information to assist you in exercising an informed vote in the forthcoming referendum, and to encourage you to learn more. We know that sometime from late October we'll have a referendum. That means the process under Section 128 of the Constitution will be put into action. First, we'll have a bill passed through the Parliament that suggests a new section to be inserted into the Constitution. Then that proposal will be put to the Australian electors to decide whether or not to insert the section into the Constitution, with the change only occurring if a majority of electors in a majority of states, as well as a majority nationally, vote in favour of the change. The proposal is to insert a voice to Parliament and government. Enshrining the voice would be an act of constitutional recognition of Aboriginal and Torres Strait Islander peoples. It's to be a representative body of First Nations, which will be given the function of making representations to the Parliament and government. That is, a body to provide a guaranteed process to get First Nations views to Parliament and government about things that affect First Nations peoples. Where did this idea come from? We can go back to the early days of the Australian colonies, or from Federation, when First Nations groups asked for a say in political decisions made over them. Given that the British imposed their law on this country in 1788 without the consent of the First Nations peoples, and then set up laws that were discriminatory against those peoples. In terms of the operation of British colonial law and then Australian law, we can start with the operation, in fact, of terra nullius, whereby the prior claims of possession, occupation, any form of ownership or control by First Nations were, in a simplistic overview, ignored by the colonial authorities. While there was an early period whereby some colonial authorities chose not to intervene in disputes which involved only Aboriginal people, the operation of colonisation quickly led to the assertion of British law as the only law recognised and operative on the Australian landmass. After the creation of the 6 colonies, colonial law recognised Aboriginal and then Torres Strait Islander people as having the same formal legal status as non-Indigenous people. But the rights and legal independence which usually come with that status were denied to them. Stark examples include restrictions on political participation, as well as basic freedoms of movement, being free to choose whom to marry, whether and how to hold property and wages, and then the legal system which supported the Stolen Generations policy for 60 years, between 1910 and 1970, including the forcible removal of children on the basis of their Aboriginality. So it's a straightforward legal history of extreme discrimination while holding the formal legal status of British subject or Australian citizen. But that fails to make clear the destructive effects of the practical reality of the way in which colonisation occurred, which you can see in records of dispossession, frontier warfare and other accounts, leading to intergenerational trauma and disadvantage. That background is just to explain the impact of colonial and Australian law against which Aboriginal groups and leaders then rallied in seeking a voice in the decisions made over them and about them. To give an idea of the long history of calls for a voice to Parliament and government, I can identify a series of examples. We can start with colonial examples, including petitions, such as one by Tasmanian Aboriginal people to Queen Victoria regarding an agreement with Governor Arthur in 1846, or one by Wurundjeri elder William Barak regarding the Victorian Aboriginal Protection Bills of the 1880s. After Federation, examples include David Uniapon calling for autonomy, Frank Maynard calling for the abolition of the protection and control arrangements regarding Aboriginal affairs. In the 1930s and 40s, there were multiple calls for representation in federal parliament. including by Yorta Yorta man William Cooper, Joe Anderson, known as King Burriga, and the Australia Aborigines League. Later examples arise in particular from the Yolngu in Arnhem Land, the Yirrakalabak petition in 1963, and then the Burunga Statement in 1988, calling for treaty. In the meantime, we had the 1967 referendum, which removed some words from the Constitution. The race's power was amended to remove the exclusion of Aboriginal people in the states from its scope, thereby granting the Commonwealth Parliament power to make laws with respect to them under the broadened race's power. Section 127 was deleted to remove the exclusion of counting Aboriginal people from the census for various constitutional calculations. Neither of those constitutional changes affected the structural issues being railed against since colonisation. And ironically, they meant that Aboriginal and Torres Strait Islander peoples were then completely absent from the text of the Constitution. Of course, we can also mention the Mabo No. 2 decision of 1992, which marked the moment when the High Court recognised that the doctrine of terra nullius was based on a historical fallacy, and sought to reach a compromise of retaining dominant British sovereignty while recognising some native title rights, if they were not inconsistent with property grants made under Australian law. The Mabo decision was a significant statement that the legal system saw that Aboriginal and Torres Strait Islander law existed in fact, but continued to maintain that it was not given authority on its own as law. So coming back to the Constitution, more recently we had federal politicians entering the fray, suggesting constitutional recognition of First Nations. Prime Minister John Howard proposed a symbolic recognition in the preamble in 1999 that would mention Aboriginal and Torres Strait Islanders the nation's first peoples. That was defeated at referendum, and the idea of a symbolic recognition with no legal force was rejected by First Nations peoples. What followed over the next 15 years was a series of inquiries and proposals by legal experts, but where there was no agreement by Parliament and no consensus on what form recognition would take. So that brings us to the Uluru Statement from the Heart. After politicians suggested constitutional recognition and a series of Prime Ministers talked about it, there was never a clear agreement as to what that would mean or what form it would take. The expert panel on the recognition of Aboriginal and Torres Strait Islander peoples in the Constitution was established in 2010. It reported in 2012 with a series of proposals. A joint select parliamentary committee was established in 2014. But with no clear path forward, a group of First Nations leaders met with the Prime Minister Malcolm Turnbull and opposition leader Bill Shorten and issued the Kirribilli Statement in 2015, asking for clarity from the Prime Minister and opposition leader as to the parameters of what they would support in relation to constitutional recognition, and urging engagement with First Nations peoples. Essentially, it was a call to allow First Nations to come up with a proposal, given the lack of political leadership and will within the Parliament and federal government over decades. In December that year, 2015, Prime Minister Turnbull announced the establishment of the Referendum Council that would oversee a deliberative process designed and led by First Nations peoples. What followed was a series of 13 dialogues across the country with First Nations peoples, resulting in the Uluru Statement. So the Uluru Statement in 2017 was the result of a First Nations-led process to identify what First Nations wanted from constitutional recognition, as the latest in that very long history of calls for a say over the law and policy that applies to, and so often disadvantages, Aboriginal and Torres Strait Islander peoples. The answer to what First Nations peoples want, as set out in the consensus position of the Uluru Statement, is voice, treaty and truth. Before coming to those elements, let me briefly outline the dialogue process. The dialogues were a deliberative process across the country run over 2016 to 17, run by First Nations peoples for First Nations peoples, bringing together the largest and most extensive consultation process of First Nations. In fact, one could argue that it was a process that was more consultative than any other political process in our nation's history. The dialogues were conducted in regions across the country, with Secretariat support from the Australian Institute of Aboriginal and Torres Strait Islander Studies, IATSIS. The purpose of each dialogue was to get a robust representative sample of First Nations views about recognition and reform. A local land council or similar representative body hosted each dialogue as a partner with IATSIS. The participants were organised through a formula of 60% from traditional owner groups, 20% from local community organisations, 20% local community members, as well as members of the stolen generations. That formula sought to capture cultural authority, local needs, and avoid domination by particular groups or individuals. Each dialogue was capped at about 100 people and lasted 3 days. First, there was a civic session, then plenary discussions, breakout groups, and then the participants settled and agreed on a written record of their meeting. The only non-Indigenous people were advisors for the civics component, and they did not engage in the dialogue discussions themselves. The representatives of those dialogues then met at Uluru, at the National First Nations Constitutional Convention. The delegates of the convention drafted the Uluru Statement to reflect the consensus position of the dialogues held across the country, the outcome being the call for voice, treaty, truth. So what are those three elements? Voice is the voice proposal we see coming to referendum, and I'll come back to that shortly. Treaty is a coming together of First Nations peoples and the Australian state, a process of agreement making. You'll see reference to the term makarata, which is a Yolngu term, which can be translated as a process of coming together after a struggle. Truth is a telling of the history of our country, so we can understand the reality of what has happened since the British arrived in the late 1700s. If you've not read it, I'd encourage you to read the statement. It's short, available in multiple languages, in written and oral forms. Now let me focus in on the voice. The voice proposal is the only part of the Uluru Statement that needs constitutional change. There are two main reasons for it being placed in the Constitution. First, it has to be entrenched in the Constitution so that it is a statement of constitutional recognition of First Nations peoples. Second, so that the existence of the body is guaranteed. Unlike other representative bodies or structures, you could think of, for example, ATSIC, the voice can't then be disbanded by the Parliament if the government doesn't like what it sees or hears. Constitutional enshrinement would also confer upon the voice a legitimacy and democratic force through the process of enshrinement, involving the Parliament and the electors. Before I go to the details of the provisions, it's worth noting how the voice proposal is something different to other proposals that have been made with respect to Aboriginal and Torres Strait Islander peoples. There have been multiple proposals for constitutional amendment, either to amend or remove the races power, remove the redundant Section 25, insert a non-discrimination clause, amongst others. The voice proposal is something different. It is not about race. It is not simply changing some of the existing words or granting the Parliament a new power. It is to establish a new institution to redress the political powerlessness of Aboriginal and Torres Strait Islander peoples and recognise their distinct status as Australia's First Peoples. So now to the details of the provision. The proposal has been drafted in consultation with both First Nations leaders and constitutional law experts. It starts with a preambular statement of recognition of Aboriginal and Torres Strait Islander peoples as the First Nations of Australia. This would make it clear that the voice is a recognition of First Nations peoples. Following the referendum in 1967, there is no mention at all of First Nations peoples within the text of the Constitution, and no explicit reckoning with the historical reality of First Nations being here from before colonisation. Then there is the key statement that there shall be a body called the Aboriginal and Torres Strait Islander Voice, and then an outline of its key function, that the Aboriginal and Torres Strait Islander Voice may make representations to the Parliament and the Executive Government on the Commonwealth on matters relating to Aboriginal and Torres Strait Islander peoples. This captures the core of what the voice is about, and to answer the call made in the Uluru Statement for structural reform to address political powerlessness. Then the final part is a conferral of legislative power on the Parliament, so that subject to the Constitution, the Parliament can make laws with respect to matters relating to the Aboriginal and Torres Strait Islander voice, including its composition, functions, powers and procedures. Now I'm going to explain how the proposal for the voice is consistent with Australian constitutional structures. The first point to make is that the design is similar to what we see in the design of other institutions. That is, the Constitution sets down the basic details, the existence of an institution, its basic role, and then the other details are left for the Parliament. That's what we have in general terms for the establishment of the Parliament itself. That's what we have for the High Court. And it's not only common in our Constitution, but is the way many constitutions are set up. We guarantee the core components and then leave the details for ongoing negotiation over time with the Parliament and the people to allow for change. This approach is particularly appropriate for the voice because it allows, for example, for First Nations to negotiate with the Parliament about how they are to be represented by the voice and for that to change as is necessary. The identity and cultural traditions of First Nations across Australia are complex and diverse, and their composition and laws are not static. First Nations peoples are heterogeneous, with distinct internal rules for membership and structures of representation. Acknowledging this leads to the conclusion that the best way to ensure that First Nations determine the membership of the voice is to have the rules of its membership contained in legislation, the drafting of which is informed by and amenable to refinement and change in collaboration with First Nations people. We also have design principles approved by Cabinet regarding the voice that would guide the legislation in due course. These include that the voice will be chosen by Aboriginal and Torres Strait Islander people based on the wishes of local communities, and it will be representative of Aboriginal and Torres Strait Islander communities. It will be gender balanced and include youth. That it will work alongside existing organisations and traditional structures, be accountable and transparent, be empowering, community-led, inclusive, respectful and culturally informed. In terms of how the voice will interact with the Parliament and Executive, we know that the design principles include that it will give independent advice to the Parliament and Government. It will not have a program delivery function, and it will not have a veto power. The voice will make representations to the Parliament and the Executive Government, but the Parliament will decide what impact those representations will have. It will be up to the Parliament of the day to decide whether the Government has to take into account the representations, or if the representations will be just one of many considerations when the Government exercises its power. That is, the Parliament will decide from time to time what, if any, legal impact the representations will have. In having the constitutional provision indicate an outline of the main function of the voice, and then a conferral of legislative power, the design and structure of the voice fits within our constitutional system, whereby the Parliament has the main role in implementing the reform and determining the details. The existence of the voice and its role of making representations will be protected by the Constitution, but all the other details will be able to be changed by the Parliament. It therefore fits within our political system, whereby the people elect the Parliament exercises legislative power to confer functions on the Executive, and sets up the rules whereby that power is to be exercised and controlled. Of course, the judiciary is also a key part of our system. It acts as a backstop to ensure the Parliament operates within its power. But judicial review of legislation is conducted prudently. It is rare for the court to strike down legislation, and the dominant approach of the court is to defer to the Parliament on matters of policy and detail, and to only police the outer boundaries of power. We can expect much the same in relation to any legislation regarding the voice, even while we can't prejudge exactly what the court would do in advance. Now let's turn to how is this voice supposed to work? What is it supposed to do? A constitutional First Nations voice is intended to be both symbolic and practical. It would be a statement of who we are as a modern nation, recognising the place of First Nations peoples as part of our polity and their distinct history and cultural connections to this land. The Constitution indicates who we are as a nation, who belongs and how power is exercised. So our Constitution is also both symbolic and practical. Changing the Constitution to guarantee a First Nations voice would be an important statement that we have moved on from our historical exclusion of Aboriginal people. But the voice is designed not to be an empty bureaucratic structure or a mere rhetorical symbol that won't achieve real change. It is intended to be the vehicle for practical action to address Indigenous disadvantage. The practical impact of the voice is that it would guarantee a facility for First Nations views to be received by the Parliament and government. Because as we know, decisions about First Nations are so often made without them or their input. And our system of parliamentary democracy is majoritarian. So given the numerical minority status of First Nations peoples, they can't have proper representation through that system. Individual Aboriginal and Torres Strait Islander members of Parliament will continue to represent their local electorate or state or territory, and of course the views of their political party. But there will be an institution, the Voice, to speak for all First Nations peoples without the party political and electoral limitations imposed on members of Parliament. The Voice would be established as an institution, entrenched in our political system of government. The Voice has been designed to be a body which is representative of First Nations and able to give the Parliament and government advice on what impact decisions, laws and policies have on First Nations peoples. Think of any of the recent and more historic decisions, policies, laws, government practices that have had a detrimental impact on First Nations peoples. Think of the disadvantage experienced by First Nations peoples across areas of life as diverse as education, health, life expectancy, incarceration, employment, cultural protection, and of how government policies and laws have failed to respond to them. The annual reporting of the Closing the Gap data is a good way to get an idea of the areas of law and policy that would likely be the focus of representations by the Voice. A Voice could provide the lived experience and expertise of First Nations to explain how the government could and should respond to each of those issues. A Voice would provide the advice the government and Parliament needs. Will the government always listen and do what the Voice asks or suggests? Maybe not. Those will be political decisions for the government and Parliament of the day. What will change is that First Nations voices will have a guaranteed place in the political discussions. A guaranteed structure through which to inform the government about issues affecting First Nations. This is part of a long game, not a short political fix. The Voice is to acclimatise Australian public institutions to listen to First Nations, with the aim of incremental change over time to make better decisions. When the Parliament passes laws, they would do so fully aware of the impact the laws may have on First Nations. When the government is making decisions and devising policies, they would do so informed of what it will mean and how it will affect First Nations. We, the Australian people, will be able to see how the government and Parliament navigates this information and form our own judgment. And I think a better informed government and Parliament is better for us all. The Voice also has a broader purpose in keeping with the calls made in the Uluru Statement, and that is to set up the conditions for treaty and truth-telling. The groups who came to Uluru understood the political and legal realities of the Australian system. In order to have an equitable negotiation for a treaty, there is a need for a structure that can bring First Nations together in a way recognised by the state and which has a guaranteed place in the Australian system. It's needed for the two to come together. It's a way for First Nations groups, their laws, their rules, their ways of being, to remain in the hands of First Nations peoples, and then to have a point of contact between the two systems. So that links in with what we hear about sovereignty. Some raise concerns that the Voice would cede First Nations sovereignty. The answer is, it can't. First Nations sovereignty is drawn from the connection of First Nations with their lands and waters and their laws and their internal authority. As the Uluru Statement says itself, First Nations sovereignty coexists with the sovereignty of the Crown. We live in a reality where there are multiple laws and legal systems operating in the same physical space we call Australia. It's just the reality of colonisation means that the Australian legal system will only apply Australian law. The voice would neither cede First Nations sovereignty, nor would it cede the sovereignty of the Crown. The Uluru Statement is the source of this proposal for a voice, and that statement is described as an invitation by First Nations peoples to the Australian people to walk together in a movement for a better future. The voice proposal is therefore a First Nations proposal arising from that statement, as written by First Nations peoples. It is not a politician's or a government proposal. The only way the voice can be brought into reality is for the Australian electors, 97% of whom are not Indigenous, to accept the invitation of the Uluru Statement through a referendum. Hence the need for the government and Parliament to get involved at the first stage, because they need to present the proposal for change to the people in the form of a bill to Parliament. That's how changing the Constitution works. The voice proposal is a modest yet potentially influential reform. It is the latest in a very long series of calls by First Nations peoples to provide them with a voice in how law and policy operates over them. It was developed out of a representative and consultative process, bringing together First Nations groups from across the whole country. It is structured consistently with the way we set up other institutions in the Constitution. There are existing approaches and structures which can be used to determine the legal impact of representations by the voice. And as is appropriate and orthodox in the Australian legal and political system, it will be for the Parliament from time to time to determine the detailed operation and legal impact of the voice. I hope this presentation has affirmed some of what you may already know, has given you some more information and context to understand the voice, and that you feel you're more informed in exercising your vote in the upcoming referendum. Stay informed, talk with your families and communities, and take an active part in this referendum.